So today we have Susan Maslow here. She's a wonderful attorney at Antheil Maslow, and I always forget the third name in your law firm's name. So I'm sure you'll help me out on that one.
MacMinn, yeah, yeah.
Okay, yeah, thank you.
Good guy. Yeah.
And I'm sure he is. And so Sue has been a lawyer for many years, and she's been involved in the business and human rights community for a number of years as well. I'll let her talk a little bit about that, but we're hoping to learn today about the model contract clauses for the protection of human rights, which is a project that she's been working on for a number of years. So thanks, Sue, for joining us today, and maybe you could tell us a little bit about yourself and a little bit about this model contract clause project.
No, thank you, Patrick. So yeah, as Patrick says, I have been a business lawyer for over 40 years, and representing in the beginning for about 8 years just transactional work with a big law firm, and then with the Antheil and MacMinn fellows mentioned earlier, opened up my own practice. Um, I came to human rights and what we could possibly do from the business lawyer perspective as a result of actually some volunteer work in Guatemala over the course of several years, and confronting the health risks of coffee pickers,
Okay.
which are and were substantial, and realizing that that in many ways the life that we enjoy here in the U.S. is a product of how harsh and difficult life is in South America. So that's how I kind of came to this place. Um, I am vice chair of the working group that drafted the model contract clauses to protect human rights in supply chains. And that project was born of frustration and hope. Frustration because so many companies had adopted the Universal Declaration of Human Rights, or the UNGPs, and posted those wonderful policies on their websites, but did absolutely nothing in the way of operations to incorporate those principles. And the hope was that the working group could define some of the key terms, like, what is modern slavery and what is child labor, and what are defective goods, and present these clauses to help companies operationalize those principles that they said, and sometimes in great sincerity they wanted to follow.
Yeah,
So that's
so
kind of me. Yeah.
so that's your background. You've been you did so much work in the corporate law sphere, and then you wanted to shift towards the kind of emerging business and human rights sphere, after the passage of the UNGPs and after your experiences in Guatemala, and then after I think it was David Snyder who was initially at a ABA conference for a business law section meeting where you and he started discussing the idea of model contract clauses. What was the problem as you articulated it then? You often say that there's an issue with respect to a perfectly stitched soccer ball, but it was stitched by child laborers. Maybe you can
Sure.
discuss that.
S- So the problem is that really commercial law did not and does not really address the idea of goods that otherwise follow all specs in terms of materials and raw materials, tension, mobility, all of those features, but have been tainted by child labor or modern slavery. So the UCCs, or the contracts for the sale of international goods, the CISG, which is used in Europe and other countries, has a very well accepted and used body of clauses that merchants look to frequently, and litigators look to regularly, to define their relationship. And David came up with the idea to look to those two bodies of law and see if we could tweak them just a little bit in a way that might be acceptable to merchants, to exclude or give them the same rights of rejection, and an opportunity to cure, perhaps, when the goods were tainted but otherwise followed all specs. So that was the idea. And version 1.0 very much looked to the UCC and the CISG in that context and had traditional reps and warranties from the supplier, which was sort of the standard in 2018 when that version 1 was first published. Real quickly, we went on after version 1.0. We entered into consultations with over 70 different manufacturers, NGOs, civil societies, trade unions, you name it, as well as the merchants, and realized that the rep and warranty structure, although it was comfortable for business lawyers, really did not work in this context, because even if a representation like there is no child labor or forced labor in my supply chain, check, is true at the moment that the contract is signed, this is a ever-evolving risk factor, and we needed to come up with an alternative to the traditional rep and warranty structure to make it work, to, again, take the policies beyond words on the page and see them actually in operation. So version 2.0 has a shared human rights and environmental due diligence obligation. It's ongoing. It's permeates every aspect of the relationship, and it's just as important as, again, the specifications I mentioned in the beginning with respect to raw materials and tension mobility for a particular good.
That's a really helpful summary. And my understanding is that I guess full disclosure, so I've been involved in the project ever since version 2.0 was created. So I've been involved in the efforts to publicize the project, get the word out there, explain to companies and other stakeholders why it's important to incorporate these clauses, and helping companies incorporate the clauses. I wasn't involved in the drafting of this, so I really appreciate your giving us the background and how both sets of clauses were originated. And it sounds like version 1.0, the focus was just on ensuring that these were, process defects, what we call them, taints of human rights and environmental risks, environmental taints, that they are on the same level as product defects, and they're a material term in the contract which allows for remedies, certain remedies. But that placed a lot of responsibility for potentially breaching those obligations onto the supplier. And then and that was a great step, because at least that now put these human rights and environmental criteria into the contractual documents themselves. So it was a big step forward. But then once you were able to circulate it and ventilate it to the wider community, socialize it to the wider community of stakeholders, it became apparent that in operational terms, oftentimes the constraints put on the supplier by the buyer have a human rights impact and effect. So maybe you can talk a little bit more about what was discovered with respect to why it became so important to at least incorporate or give life to potentially buyer obligations.
Well, the gist of it, I think, is that the rep and warranty structure is unrealistic because of what I mentioned in terms of ongoing non-static risk factors in the supply chain, and also dangerous. And the rep and warranty structure was dangerous because it absolutely discourages supplier disclosure upon discovery of what might not yet be a human rights abuse, but will soon turn into such an abuse or impact if not addressed. So if the goal is to jointly address and remediate problems and rehabilitate conduct in a way that reduces the chance of a human rights abuse or a negative environmental impact, then we need to share information, and we need to come up with a process that allows the supplier to say, yeah, we've got a serious grievance that we are addressing to figure out how widespread it is, and the effort is to contain in scope and severity any kind of discovered problem, rather than to punish in a more traditional fashion a breach of what we call a Schedule P, which is the policies which was incorporated in version 1 and abandoned in version 2 in favor of this rehabilitation, um, joint addressment of any problem.
Yeah, no, yeah, I think it's important that you have enforceable obligations, but we don't necessarily want them always to be enforced. And realistically, it's unlikely that they would be enforced as standalone obligations, unless there are damages that flow from them. Um, what you want is you want to incentivize disclosure of these obligations, because a
Right.
lot of what the regulations that companies are now um, required to abide by relate to human rights due diligence, so discovery of risk. So if you're putting in contractual obligations that disincentivize disclosure of those risks, you're inhibiting the whole process. And then the secondary point is, if you're doing proper due diligence, it's very likely that you will uncover some human rights or environmental issues along the way. So it's imperative to have a structure in place so that you can address those human rights risks rather than simply terminating the agreement.
Absolutely. I mean, I tell clients that are interested in this space all the time that if you are getting monthly or quarterly operational grievance level reports that say that there's no problem, then there's a problem
Yeah.
with the process.
Yeah, there's a problem
You
with your measuring device. Yeah.
exactly. Yeah.
Yeah.
So, and the goal is, the goal certainly is to eliminate any kind of human rights abuse or environmental impact, but realistically, small steps, let's get to a place where we are addressing those that we discover and go from there.
And so
Especially,
no, no, no.
yeah, especially, I guess the real question is to move away from what was plausible corporate deniability, which was very comfortable, saying, I don't know of any human rights problem in my supply chain, and to instead sort of face that this is a risk and it requires a risk analysis, just like, all other company risks.
Mhm. Yeah, I say the era of ignorance is over in this space.
Right.
And can we talk a little bit about, so I think version 1 was issued around 2016 and version 2 was around 2021. Is that about right?
So version 1 actually is 2018, but 2002, you're totally right. That was published in 2021.
Yeah. And can you
Yeah.
tell us a little bit about the process of promoting these clauses and how the evolution of regulations in this space have assisted in your ability to promote and convince companies that these need to be implemented?
Sure. I mean, I'd love to say that we were incredibly foresightful and knew that there was going to be this wonderful evolution of soft law to hard law. But I don't think we ever anticipated that it would be as timely as the project has become, or that there would be this really pretty very short timeline where the German law, the Uyghur Forced Labor Prevention Act, now as of yesterday, possibly the CS3D, the Corporate Sustainability Due Diligence Directive out of EU. All of these hard law initiatives have certainly made it a lot easier for us to market, forgive the word, the model contract laws
Promote the
project.
implementation of
Promote.
these clauses.
Right,
Because
right,
we should say at the outset, this was a initiative from the ABA business law section. These clauses have always been public. The thought has always been, and one of the things that attracted me to this working group to begin with was the the purpose was that these clauses would actually help out companies and individuals and stakeholders, and they would actually be implemented and actually be effective. It wasn't just to make a buck, as it were.
right, right. No, that's absolutely true. And for that reason, we've shied away from a business affiliation with any software provider, those kinds of or even consultants in their capacity as a service provider. But there is a toolkit that, and actually now there's also supply contract clauses, which are written a little bit more favorably for the supplier, and European model contract clauses that are, I think, are part of the Responsible Contracting Project website as well. And we hope to have responsible investor model clauses published sometime next year.
Yeah, it started off as this discrete project that kind of
Right.
addressed UCC concerns, and it was an ABA initiative, so obviously a US lawyer-led initiative, and then it's now expanded to address the EU clauses. I want to backtrack a bit to the evolving kind of soft law to hard law issue, because some of our audience might not be aware of the German law you're referring to and the UFLPA, so let's just backtrack a bit. When the version 1.0 was released, and then even when version 2.0 was released, I remember the key features that we would explain to companies as to why these should be implemented is because these companies had their human rights policies online, and if they wanted to ensure that they were operationalizing those policies, implementing those policies, they needed to ensure that their contracts reflected those policies. That in and of itself was, certainly logical and made sense, but it wasn't necessarily sufficient to get a lot of companies to implement more and more ambitious contractual frameworks. So we would add things like, reference to the reputation risk of discovery of these issues. If you look at companies that were implicated in the sweatshop crises in earlier decades. So there's a reputation risk. Then we would point to potential litigation risk. So we would point to shareholder derivative suits or suits brought under the Alien Tort Statute or the TVPRA. So there were these, and we would highlight investor sentiment and the growing ESG investor kind of categories. But even still, it wasn't necessary. There were some companies that were, eager to implement clauses like this and frameworks like this. But now that we have first the French duty of vigilance, and then really the German law that relates to human rights due diligence and requires companies subject to the law to conduct human rights due diligence, that's really started to focus companies' attention, such that companies who are subject to the German law are particularly willing to incorporate a contractual framework like this because they feel like it adequately addresses their compliance concerns. So that's the German law. And then separately, we have the Uyghur Forced Labor Prevention Act in the US. And now I'm conscious that I've been talking for about 3 straight minutes. So maybe you might want to talk a little bit about the Uyghur Act, because I'm supposed to be asking you these questions, although I appreciate that when we give presentations, UFLPA is often what I talk about.
True. So I guess I want to mirror the 4 factors that you mentioned in terms of before the evolution of hard law in this space. We were talking about reputation. We were talking about investor concerns. And we were certainly talking about consumers, which might be the same thing as the reputational risk. But in each of those areas, actually, in addition to the evolution of hard law in this space, there's been a lot of growth certainly in the investor world in terms of interest in ESG factors like the ones that we're talking or hope to address with the model contract clauses. So you've got an additional emphasis in each of those places, along with the increased enforcement by Customs and Border Protection will withhold release orders that you're referring to, either under the Uyghur Forced Labor Prevention Act or the North Korea sanction, as well as just the amendment to the Tariff Act in 2016, which removed what that was called a consumer
consumptive
exception,
demand exempt.
consumptive,
Yeah,
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 that actually swallowed, the Tariff Act prohibition
yeah.
with respect to the importation of goods that were tainted by forced or child labor. So we've got a whole bunch of factors that are all pushing towards corporate implementation of clear requirements to to find areas within their supply chain that they could improve in this context. So I think you've got all of those pieces. And it's an exciting time, to be working in this space. I think it's really fascinating.
Yeah, no,
We
but yeah, no. So with respect to the era of ignorance in your supply chain being over, the idea is that we as lawyers have to advise our clients that in order to meet the regulatory challenges from the EU, which are requiring you to conduct human rights due diligence and to mitigate risks when you identify them and to address them, that effectively requires implementing some type of contractual framework. In the US context, we have the prohibition of goods produced using forced labor, and then the quasi-prohibition of goods produced which have a nexus to Xinjiang, or the effective prohibition, given the difficulty in rebutting the presumption of forced labor. So companies who are interested in importing into the US also need to have an understanding of their supply chain so that they can assess the risk of forced labor, so that they could mitigate any risk that the US Customs Department could stop their importation of certain goods that they feel are potentially produced using forced labor. So companies need to have a contractual way of obtaining reliable data on their supply chains.
So yeah, I think that's a really important point with respect to many of these new hard law requirements have um, a provision or two or three or four that either requires contractual provisions to address these kinds of problems, or have reporting requirements or data collection requirements that trigger the requirement to have a contractual provision that would allow for the collection of data. So again, we're not alone in promoting the role of contracts to operationalize policies any longer. We now have specific legal requirements in many of these laws, specifically the German law, and we haven't seen the final draft of the corporate sustainability due diligence directive, but it
That's
certainly
the
paragraphs.
EU-wide law. That's effectively that's similar to the German law, but it would apply EU-wide.
Correct. And the first draft that we did, or second draft that we saw as well, all had specific contractual requirements as part of the entire legislation. So we are, raising our hands and saying, if you're looking for contractual provisions, we happen to have them. They're right here.
And as a matter of fact, you and David have recently released a book on the model contract clauses. Isn't that right?
We have a fascinating book.
You've been working on it so hard. I had to mention it. It's a really impressive piece of work.
It is long, and I hope hopefully impressive. It contains pretty much almost every subtopic in this space, with I'm just checking 26 chapters that range from antitrust considerations, which are aplenty, because for some of the remediation you really need to have a collective of buyers. In other words, if you're the only one who's imposing certain requirements on a factory, then another buyer will simply come in and get those same tainted goods that you've walked away from. So antitrust provision, a chapter with respect to the European model, a chapter with respect to transactions in commercial law and civil law, sorry, countries. Um,
I remember
care.
reviewing David's chapter on China, right? On
Mhm.
China-related issues.
right, China and other international trade, environmental clauses, including some sample model toxic environmental clauses, which are kind of incredibly fascinating. The
Let me
Caremark
linger on that point for
obligations.
a second because we have, are you familiar with SB 253 and SB 261 here in California
Hmm.
that were just passed?
Yeah,
And we talked
yeah,
about it briefly, but the model contract clauses were originally drafted to identify and mitigate human rights risk, but it's become clear that the human rights due diligence clauses can also be used to obtain reliable information so that you can report your emissions for companies that are subject to these disclosure requirements.
exactly. And there may even be a version 3.0 sometime in the future that incorporates certain technologies, blockchain technology as an example, that will again combine all of these.
I
Um,
like what
like,
when the idea was first put out there, blockchain was the buzzword. By the time the 3.0 comes across, everybody's going to be talking about AI, and now we're going to
oh,
have AI clauses or
right,
something
right,
even more chic in the tech world, right?
right. Well, again, to extent that we're looking for data, then we have to look at AI and other, it's words on a page in a contract are not going to
I mean,
generate the kind of data.
actually, when you talk to, like CBP, for instance, so CBP is tasked with trying to develop systems
Mm.
to identify goods produced using forced labor and detain shipments that are subject to that suspicion. And they have talked about how they use different AI platforms to try to determine what goods might have higher risk of forced labor. So they're definitely using that, and I'm sure, and I think private companies are also using AI to help companies map out their supply chains or at least assess risk. Um, so another California issue that I wanted to talk about was the recent decision related to the business judgment rule in shareholder derivative actions, because shareholder derivative actions are one space where activist investors, entities like As You Sow, for instance, are putting pressure on companies to implement human rights and environmental policies. So I wanted to talk to you a little bit about this case because we mentioned it offline. Maybe you could tell us a little bit about the Caremark business judgment rule and then the California case.
Sure. So the original Caremark, I think it was Caremark International case, dealt with healthcare providers and the providing of managed care. And it was a shareholder derivative suit that alleged that the board had failed in its duty of loyalty, some people say duty of care, uh, in failing to provide an oversight system that was directed to the board and was actually brought up to that level rather than um, internally kept uh, by a lesser officer, so to speak. And it came up with an analysis that has later evolved into a two-prong uh, piece. Um, and has also been um, used repeatedly actually to uh, dismiss the shareholder derivative suits when there is no finding of actual bad faith on the part of the board because of a conflict of interest or just a total refusal to look at a risk that would otherwise come to their attention because of a red flag. Um, and the red flags can be, as evolved over the last 20 years, anything from repeated allegations of sexual harassment or other harassment in the workplace, or key services like the fact that two of the Boeing planes fell out of the sky. That was also a Caremark litigation. So it's a whole range of different kind of services that a company might provide. And the question is whether or not the board was doing its job in looking at what is sometimes called mission critical operations. another example of a Caremark case was ice cream, some kind of lethal or nearly lethal or fatal, I should say, germ that permeated ice cream and resulted in the death of many, and that also resulted in a Caremark claim. Um, so over time, courts have said that it's a pretty high hoop to jump over. In Caremark, you need to, as I said before, prove bad faith on the part of the board. But I think what's really interesting in this context is that the Caremark decisions and guide to what they perceive of as appropriate board behavior to utilize the business judgment rule, which is the opportunity to say, look, we did what we thought was best at the time. The courts are not in a place to tell the board how to work. We invoke the business judgment rule, and more often than not, courts are respective of that argument. So in June of this year, California, for the first time, adopted that Caremark analysis and dismissed a case on the basis of findings that the board did have a monitoring process in place, and that it did, on occasion, look at the results of that internal process, so that it could refuse to let the derivative shareholders case go forward, and it did. So some people look at this, the Caremark decisions, and certainly California's adoption of that standard as a negative. Ever an optimist, look at it as a further encouragement to California companies to be sure to adopt contract provisions in their supply chains that at least can be used, if they're followed, at least in some minimal way, to defend against a shareholder derivative suit when and if a human rights or an environmental adverse effect arises.
Yeah, I think the balancing is, so this reminds me of law school administrative law, the kind of Chevron deference. This seems like there's
Yeah.
a judicial deference to the business judgment of the board. So it's a deferential standard. So you could argue that California's adoption of the Caremark standard implies that courts are going to give much less scrutiny to companies where there's a discovery of human rights or environmental issues, and that's, unfortunate for stakeholders. But the point that I think you're trying to make is that in order to have a legitimate business judgment, you need some data, some reliable data upon which to make a judgment. So now we're again not in the era of just ignorance of your supply chain, ignorance of the tiers. Now you have to be able to at least make a judgment on risks. And in order to do that, you need to obtain reliable information. And once you obtain reliable information, you also need to have some type of mechanism to address risks that you've identified.
Absolutely.
So it goes back to this function of, because and that's kind of it in more broader terms. That's part of the thought process that activists have put forward for why human rights due diligence laws are going to be effective, is because if you're forcing companies to, it might be impractical today to tell companies that they have to completely clean up their supply chains. But if you tell them that they have to have an understanding of their supply chains, it'll be incumbent upon them to address serious issues once they've identified them.
Well, I absolutely agree. And certainly in Europe and in many other countries or continents, there is not the strict liability kind of analysis that we do find under the Uyghur Forced Labor Prevention Act or the North Korea Act, where any goods that are tainted, regardless of the efforts of the company, will be held at the court. There's still a lot of discussion about whether or not strict liability in this context is appropriate, whether or not safe harbors are a
Preferable.
path. But right now, the goal in Europe in particular is to address this risk and not to take the position that as soon as we find out that there's something under the required reporting requirements, that we're going to slap the company with some substantial fine, as opposed to a company that's really doing its best to remediate.
Yeah, and you can appreciate that companies have vast webs of supply chains. They have limited ability to control, certainly beyond the first and second tiers, they have limited ability to control even the larger companies. So putting too much pressure on them is unnecessary. But also, you have to make sure that companies are much more aware than they were in the 90s and 2000s.
Yeah, without a doubt. And I think that's going to be an ever expanding. So I'd even say more aware than they were, last year. I think 2023, as it comes to a close, is going to be looked at as a real turning point in this space, where moving forward, the obligations of the companies are just going to continue to increase.
Yeah, so that was going to be my final question, and I think you more or less addressed it. But where do you see the law and the practice evolving in the next 5 to 10 years?
Well, I think everyone is completely aware of the dichotomy, for want of a better word, between what's happening in the US and what's happening in the rest of the world. But I think notwithstanding the permeations, let's call it, of political
Yeah.
dialogue or lack of dialogue in the US, certainly the rest of the world is continuing to address some of these life-threatening environmental issues first and foremost, probably, and then also human rights impacts outside of the context of environmental law. In the U.S., I think what I think is happening is that because of investor concern and BlackRock, State Street, all of these huge investment fund, at least rhetoric, some people call it greenwashing or freedom washing, that the companies are going to continue to try to adopt better policies with respect to both the environment and ESG in general, with the S standing for the worker, the stakeholder context. Notwithstanding the discussion in the US and some laws, some states that are trying to fight or oppose such developments, I think the companies in the US, especially those that have global operations, have decided to proceed with their policies, notwithstanding pushback.
Yeah, you
So
should
that's kind
mention
of,
that the EU
yeah,
laws will apply to American companies and other foreign companies that do business in the EU. So
absolutely.
US companies and US lawyers need to be cognizant of those laws and their kind of refined regulatory approach. And similarly, I think that you could argue that in the U.S. context, there's a lot of different political disagreement. There's certainly political disagreement with respect to kind of the ESG buzzword. But the interesting thing about the politics of forced labor is that you do find conservatives who are more lean towards protectionist trade policies, and maybe liberals who lean towards human rights and environmental regulations. There is an alliance between those two political forces towards having companies implement policies that will at least help them to identify issues in their supply chains and potentially make it more likely that they shift to friendshoring or nearshoring or onshoring or any of these
Mhm.
different different terms that people are throwing around.
Yeah. No,
So
good point.
even though there's, there's broad, problems, there are some opportunities in this.
No, absolutely. I think, what remains very troubling are articles like the one in the New York Times, I guess. I can't remember if it was Monday or Tuesday, with respect to the roofing industry and the use of child labor, and the states, and I think there are maybe 10 to 12 in number, that are trying to go backwards with respect to child labor laws here in the US. But that's perhaps a discussion for another day.
Yeah, 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 yeah. Let's end on a positive note.
Yeah.
Um, well, I just want to say on a positive note, thank you so much for the work that you and
Yeah.
David and other contributors like Sarah Dadouche and Olivia have done to bring the MCCs to life and to promote them and to help companies to implement these policies that I do believe will have a positive effect for a lot of stakeholders around the world. So we really appreciate the work that you've done and are continuing to do. And I
Oh, thank you.
appreciate you coming on today to talk with us.
No, again, thank you for the opportunity, Patrick. Yeah.